It's time for Preserving Your Dignity and Your Money, Planning for Successful Aging with Nugen Law. And now your host, J. Bryan Nugen, estate planning and elder law attorney.
Good morning, and welcome to Preserving Your Dignity and Your Money, Planning for Successful Aging with Nugen Law. I'm attorney J. Bryan Nugen, founder of Nugen Law, and your host for our program. The purpose of our show is to have weekly, in-depth conversations about matters relevant to folks as they walk down the path of successful aging. Our listeners will learn what it is to age with dignity and how best to protect their money. I've been practicing law for 3 decades. I'm licensed to practice in Indiana, Ohio, Michigan, and Florida, and actively represent clients in all 4 states. My practice, the attorneys, and our interdisciplinary team of professionals who practice with me concentrate on working with clients in estate planning and elder law and areas related to them, such as protecting money from nursing home stays, securing benefits from programs like Medicaid and the VA, geriatric care coordination, estate and trust administration, guardianships, and planning for those with special needs. Nugen Law sees clients in many stages of life, but commonly we have folks reaching out when they or a loved one are showing signs of needing help. Those signs may include a chronic ailment or progressive decline before, during, or after a hospitalization, an instance of incapacity, caregiver burnout, stress on family members due to some or all of those instances I just mentioned. So as a reminder, Nugen Law represents clients in Indiana, Ohio, Michigan, and Florida. We take a life care planning approach to client representation, meaning that not only do our attorneys prepare any legal instruments appropriate for your unique situation, without additional costs, our clients have access to our affiliated CPA firm for preparation of their personal tax return, are invited to our client-only educational opportunities, have access to our Medicare specialist who advises on what Medicare plan and supplemental plan to secure, the ability to have your legal documents revised as necessary, and when appropriate, unlimited access to our elder care coordinator, a person who assists with whatever help our clients may need as they age, including setting tours of various facilities, arrange for help in client homes, arranging moving and downsizing, and advocating for Nugen Law clients when necessary. If you hear something in today's broadcast which resonates with you, an area in which we may be able to help, please call Nugen Law at 260-925-3738. Speak with one of our intake specialists and schedule a meeting for either our Fort Wayne or Auburn locations. You are also encouraged to see us online at www.nugenlaw.com. Today, I have a member of the Nugen Law interdisciplinary team, attorney Jesslyn C. Smith, here in the studio. Jesslyn is licensed to practice law in Indiana, has been doing so for more than a decade, and is the most recent past president of Indiana's chapter of the National Academy of Elder Law Attorneys. Welcome, Jesslyn. Great having you on.
Thank you, Bryan. I'm excited to be here.
Great. Today's topic of protecting your assets as you age from the cost of in-home care or nursing home care is definitely in your lane, Jesslyn. As you know, 7 out of 10 people will need long-term care in their lifetime. Long-term care is necessitated when someone needs help with activities of daily living like eating or bathing, dressing, using the bathroom, whereas cognitive decline like dementia, etc. So my experience has been that a lot of our clients are motivated to contact us for help when they see that a loved one or a friend of the family has lost their money, their life savings after entering a nursing home or a memory care unit, and they don't want the same thing to happen to them or their parents. If your clients want to pre-plan before care is imminent, we're normally discussing a unique trust called an asset protection trust. Let's begin by having you, Jesslyn, define what a trust is, the different parties to a trust, etc. So let's start there.
Yeah.
What's a trust?
Yeah, so a trust is a contract that you create to essentially state where you want your assets or things to go, or who's going to benefit from what you put into the trust. And so the players of that trust are what we call a trust maker. That's the person creating the contract, and that's usually the client that we're working with. The trustee is the second party, and that is the person that is responsible for what is in the trust, or I also refer to them as the key holder of the trust. So they have the access then to what goes into the trust. And then we have the beneficiaries, and there's two types. There's lifetime beneficiary and ultimate beneficiary. Lifetime beneficiary is who gets the benefit while you're alive, and then ultimate is who gets the benefit after you pass away.
Fair enough. So there are dozens of trusts, dozens and dozens of different types of trusts. So sometimes I'll hear people say, oh, I don't need that. I already have a trust. But what's unique about asset protection trusts that help to protect one's money from the cost of care as we age? So cost of care could include in-home care, assisted living facility stays, nursing home and memory care units. What makes those asset protection trusts unique?
So one feature of that trust that makes it unique is that the trust maker is not the key holder. So they are not the ones with the direct access to the assets. Mm-hmm. And the second feature that is unique is that it's irrevocable, which means it cannot be amended or changed while you're alive without certain limited circumstances. There are a couple of ways to change an irrevocable trust, but it's very limited on what you can.
Right. When speaking with my clients and we're doing these types of trusts to protect their money if they have a nursing home stay or from the costs of aging, I think it's important that we underscore for them. You shouldn't go into this thinking, oh, I can change this. It's readily amendable. There are ways to do that, either through the court or pursuant to the terms within the trust. But you need to think of it as this is going to be set in stone. It's going to be permanent, and it's those elements. And as you said, Jesslyn, somebody else having the access to the funds in that trust, the key with your analogy. It's those elements that actually allow us to protect that money, protect that wealth from the cost of care as we age. What's the best time, Jesslyn, for people to start thinking about how to protect one's money from the cost of care as they're aging?
Well, that's a very unique question depending on the client's situation, as usual. We don't have crystal balls at the office because if we did, it would make our jobs easier to tell the clients when. But when you think about the cost of nursing home care or as someone ages and when they need care, they say the average age that someone enters the nursing home is age 82. So these trusts work if we can get them in place 5 years prior to someone needing care. Mm-hmm. So my general rule of thumb is in your 70s is probably the best age, the best time. You can do it earlier, as you're retiring if you want to do it. Or it could be later. We have clients that are in their upper 90s, and so they could. Well. Yes. Yep. And so they could do their trust in their early 90s, So it is very unique to the client, their longevity in their family, and those are questions that we ask the clients and go through with them during the appointments to find that out.
Sure. Yeah, I say the same thing with folks that are reaching out to me for those trusts. Sweet spot, 70, 75. My concern with doing them much earlier is that because you give up that level of control and you're having somebody else be the trustee, the manager of that trust, in your 60s is maybe a little too early, 70s. to me, seems to be the sweet spot for it, and especially when considering the average age of moving into a nursing home is 82. So that kind of spells it out for you, the appropriate time for it. Now, there are instances where we may want to do that earlier. And the instances typically that I think of is, we've had an ongoing medical concern, and the medical concern may or may not resolve itself. We have an age difference in spouses, right? We have a significant age difference. Husband or wife is significantly older than their husband or wife. And so the younger spouse is concerned, my gosh, I don't mean to be crude but if that my older spouse, if their health declines and we use our funds to provide payment for them, it may be more difficult for me to enjoy my retirement and enjoy the second half of my life. And early onset dementia. So if we have families in which we're seeing an early onset dementia, that we may consider doing those trusts a little bit earlier than the 70s. But generally, I think 70s for me is the sweet spot. But to your point, Jesslyn, I think of my own family. My grandparents lived to 100 and 102, right? They could have done these trusts up until age 95 very successfully. That isn't the case for everyone. We have clients that are late 60s that their health is very poor, and their window may already have closed to get those things protected. Do you, Jesslyn, have to put everything into the trust, or can you say, I'm going to put the farm ground in, but I'm going to leave my brokerage account out? I'll put the lake house in, and I'll put some of my savings in, but not all. Can you take that approach?
Absolutely. The client is in control of what they want to put into that trust. What is most important for them that they want to guarantee they're protecting from the nursing home.
Right.
And so if they say to themselves, I really need to have X amount of dollars in the bank because that'll help me sleep at night, knowing I have the access to that.
I think you stole my phrase. I say that.
Maybe.
I tell my clients that when they say, how much can I leave out? Well, how much do you need to sleep at night?
Yeah.
When was the last time you wrote a check for $50,000? When was the last time you wrote a check for $100,000? I'm answering my own question. Forgive me for stepping over your words, but it isn't an all or nothing, right? If oftentimes with my clients that are agricultural clients, farmers, they know that farm ground's never going to be sold. I should say they never want that farm ground to be sold. Yeah. They want to be able to pass that to the next generation. So we may, for those ag clients, put all of their real estate into this type of a trust earlier than the 70s, right? We want to make sure we don't lose the farm. Folks that have lake properties, that it's a generational property. We want to make sure that we preserve that for future generations. So oftentimes we'll put just some of the individual's assets into that. I will say, though, I encourage clients to overfund the trust. I can always get money out of the trust. I can't necessarily put money in without that penalty.
Correct.
Yeah. So if someone contacts us at Nugen Law to create one of these trusts, we arrange for the trust to be signed and funded. How does it protect money if a person eventually has a nursing home stay or has a memory care unit stay or is moving into an assisted living facility? So if that trust has been there and set up 5 years or more, how does it come into play that it actually protects the money?
Well, so Medicaid's rule is if you have transferred or given away assets within the last 5 years, they pull those assets back in to create a penalty period and say, we're not going to help pay for your care. But if you've had that trust in place for 5 years or more, those assets do not have to be disclosed to Medicaid. You're not the one receiving the benefit from the trust, and you're not the key holder to the trust. And so that is not your trust in the eyes of Medicaid. So you don't have to disclose that asset then, and the assets that were placed in there are protected.
Well, it's you don't have to disclose it, but it's not your asset. It's it's owned by a separate entity, the trust. Yeah.
Right.
And typically, the key holder is typically who?
A child, and usually it's the person that you've named as your power of attorney or your healthcare rep. So it's somebody close that you know.
And I always have a very honest conversation with my clients, right? You have 3 children. So the person that we're going to put in place as the manager, the trustee, the key holder, to use your analogy, we want to believe in them and have confidence in them. And it doesn't happen with great regularity. Sometimes I have clients that will say to me, with sadness, I don't have a child that I can permit to hold the key. I don't have somebody in my immediate family that I could trust as that manager, that trustee. So in those instances, Jesslyn, who might they consider appointing if not a child?
Well, do you have a very close friend that you have trusted over, 30, 40, 50 years, whatever it is? For instance, my best friend and I have been friends for over 30 years,
Right.
I would trust her with my financial information and everything, because I don't have children.
Right.
So I fit that box of that potentially. It could be a sibling, maybe you've got siblings. If you're the oldest, you may have younger siblings. Maybe a pastor, a preacher, somebody that you fully trust.
Have confidence in.
Yeah, and confidence.
So the trust deals with assets. So one thing that people are concerned about is, if I use that trust, how am I going to live? So does their income change with the trust? Are they still getting their Social Security?
They still get their Social Security.
Are they still
any
getting
pensions?
their pensions?
Yes.
Are they still getting their distributions from their IRAs?
Correct.
Okay.
Yeah, so we don't put those assets into the trust because we recognize you still need money to live off of. And if you really look at back to your analogy of asking them, when was the last time you spent $50,000, $100,000? People live off of just their Social Security, their pensions, and their RMDs, or required minimum distributions.
They dip into their savings when there's a major expense.
Correct.
I need to buy a new car. I need to re-roof the house. I'm going to put new windows in, a new kitchen. Yes, those things happen, and we can account for that. But it isn't a daily occurrence where you're dipping into that. So your day-to-day, your income stream is not affected.
Correct.
As a reminder, Nugen Law represents clients in Indiana, Ohio, Michigan, and Florida. Nugen Law takes a life care planning approach to client representation, meaning that not only do our attorneys prepare any legal instruments appropriate for your unique situation, without additional cost, our clients have access to our affiliated CPA firm for preparation of their tax return, are invited to our client-only educational opportunities, have access to our Medicare specialist who advises on what Medicare plan and supplemental plan to secure, the ability to have your legal documents revised as necessary, and, when appropriate, unlimited access to our elder care coordinator. This is very important. This is a person who assists with whatever help our clients may need as they age. It could stream from setting of tours at various facilities, arranging for help in client homes, arranging moving and downsizing, and advocating for our clients when necessary. So maybe you're not getting the care you believe that you need in an assisted living facility or at a nursing home, or there's a concern about health care that you're receiving. That elder care coordinator will advocate on your behalf. And all of those services are for a flat fee, value-based one-time payment. So if you hear something in today's broadcast which resonates with you, an area in which we may be able to help, please call Nugen Law at 260-925-3738, speak with one of our intake specialists, and schedule a meeting for either our Fort Wayne or our Auburn locations. You're also encouraged to see us online at www.nugenlaw.com. Jesslyn, let's get into what someone can do if they didn't speak with you. they didn't do those asset protection trusts in advance. And they thought, oh, this will never happen to me. I've told everybody I never want to leave my home. I'm never going to have any help in the home. I'm never going to go to a nursing home. I'm never going to go to a memory care unit. And then that happens. What can they do in that instance?
So in those instances, we can still protect a portion of what you have. It's not going to be fully protected. There is going to be a portion of your assets that will have to be used to help pay for your care. I tell clients at minimum 50%, depending on the type of care you're receiving. There is some care that is more expensive than other care. For instance, ventilators cost upwards in the $20,000 per month at a facility. And so in those instances, we cannot protect as much because your income really drives that decision maker there, because if you have high income, you've got more money coming in to go towards your care.
Sure.
So we don't have to tap into so much of your savings or assets.
Have you noticed a difference if someone is a single person versus a married person and how much that we can protect?
Absolutely. In a married couple situation, we can protect everything for the spouse that remains at home or in the community. Mm-hmm. We just have to move the assets around in a way to either generate an income stream or move the assets into that spouse's name that's at home if they're exempt assets, if they're in that spouse's name.
Mm-hmm. We internally, we call that crisis planning.
Correct.
Yeah. And let's talk about the quality of care. Well, before I get to that, if we've protected that money, right? We've gone through the crisis planning, or we've got that asset protection trust in place. We have that money protected, and we do need that nursing home stay. We do have to require in-home care for us to stay there or move to an assisted living facility. Is the quality of care different based upon the payor source?
No. They're going to prepare the same meals. They're going to have the same materials and things at the nursing home that they're using for the patients that are paying privately. And
same
actually,
room.
Yeah, same room. A fact that people don't realize is that about 80% of the folks that are in nursing homes are on public benefits. Mm-hmm. Because it's hard to sustain that payment to the nursing home for a long period of time.
In Fort Wayne, the average cost of a nursing home stay in the year 2023 was $111,000 a year for a semi-private room, which means 2 people in a room.
Correct.
So you can do the math and see how quickly you can run through your life savings. So I analogize what we do with protecting money kind of to a CPA or a tax preparer. I've never heard someone say to their CPA, please, I don't want to take any those deductions for which I'm eligible. Don't give me any deductions. I want to pay as much tax as I can. Don't give me any tax strategies. Don't help me out in that regard. I have never heard someone say that to me. And it's kind of the same thing that we do with our clients.
Right.
And people will look at me askance when I say, oh, we can do that. We can protect. Your grandmother sold the farm. We don't need to sell the farm. We can protect it. We can protect your money. And they look at me as if there's something, sleight of hand, or there's a shell game, or I'm doing something nefarious or bad. Is there anything we do that isn't disclosed to Medicaid, actually, if we're applying for Medicaid benefits?
No. I mean, when we're working in these crisis planning situations, what we're doing and telling the client to do does get fully disclosed to the Medicaid office at that point, because we're putting a plan in place and planning for what we're doing. And so there's no reason not to.
Yeah, for sure. And I think that we did a presentation, several weeks ago. And one of the questions that came up in the presentation is, I hear you talking about protecting assets, but what about my income? Can I protect my income? So let's talk about that. If you're a single person and I'm in a nursing home or memory, I've protected all my money, right? Thanks, Jesslyn, you did a great job. Thank you, Bryan, you did a great job. Thanks, team at Nugen Law, you did a great job. But I've got this income stream. Can I protect the income stream as a single person?
No. In the nursing home, you only get to keep $52 of your income for your personal needs.
On a monthly basis.
On a monthly basis.
Yep.
The rest of your income does go to the nursing home as your share of the cost, because Medicaid only covers approximately about 75%. Mm-hmm. The other 25% comes from your income. Right. To pay the nursing home.
Now, let's flip the script a little bit. If I am a married individual, right, so we have a well spouse that's in the community, so a community spouse, and we have an infirm spouse or a spouse that needs the help. They're in an assisted living facility, a nursing home, memory care unit. Is the same situation there true, where the infirm spouse, all of their income has to be used for their care?
No, not necessarily. Okay. So the spouse in the nursing home, if the spouse at home does not reach certain levels with their income, Medicaid has rules in place that says the spouse in the nursing home can give some of their income then to their spouse to live off of. And then we can get an increased amount on that depending on if they've got shelter expenses, such as like a mortgage or rent.
Utilities,
mm-hmm. Taxes, insurance. And so we look at that, calculate that out to see if we also can get what I tell clients is an enhanced allocation, mm-hmm. So that they have additional to keep. And if that's the case, the spouse at home, if they can get the maximum amount, is over $3,000. So in some instances, they may get to keep all of the income of the spouse that's in the nursing home.
Sure. And let's not forget, once their spouse, the infirm spouse, is on Medicaid, they could win the lottery. Mm-hmm. And is the infirm spouse still on Medicaid?
Yes.
They inherit, the person in the community spouse inherits from their parents or loved one. Can the spouse in the nursing home still get Medicaid?
Yes.
Okay. Yeah, and normally what we like to do when we're looking at couples, if we have one that's in the nursing home and one that's out, what do we do for the folks, the spouse that's in the community? What do we do to protect their money after we've got the first spouse on Medicaid? Not always, but generally.
So generally, we have two options. We put within their will a supplemental care trust language so that if something happens to them before the spouse in the nursing home, it's protected, because Indiana does state that you can't disinherit a spouse. A spouse is always entitled to something here in Indiana. Yep. So we want to make sure that that's protected so they don't lose their benefits. So we we create their will to state that it goes into a supplemental care trust. So that's another different type of trust. As you stated, we have different types, supplemental care trust are one. And so that can protect the assets then within the will. Or we look at doing an asset protection trust for that spouse then.
Right. So they may not have done that asset protection trust 5 years or more before the first spouse went in, but it doesn't mean it's too late to do that for the second spouse. And if someone has retained Nugen Law to do that crisis planning for them, if we've successfully done that, that's in place, and then we're determining that the well spouse needs to have their estate prepared or needs to have that asset protection trust performed. We do that without additional cost. That's just part of it.
Correct.
Whatever that is that they need at that time, we're doing for them and not charging them any more money for that.
Correct. It's part of our flat fee, and so they get that service. Any legal documents that we need to prepare for that are included.
I do think that gives people a sense of comfort, because they are not worried that every time I reach reach out to Jesslyn. Every time I call Bryan or somebody else from the Nugen Law team, that they're going to be nickel and dimed. Their agreements are in place for 12 months, and anything they need during that time is completely covered. So as a reminder, Nugen Law represents clients in Indiana, Ohio, Michigan, and Florida. Nugen Law takes a life care planning approach to client representation, meaning that not only do our attorneys prepare any legal instruments appropriate for your unique situation without additional cost, as I was just talking about, our clients have access to our affiliated CPA firm for preparation of their personal tax returns, are invited to our client-only educational opportunities, have access to our Medicare specialist to advise on what Medicare plan and supplemental plan to secure, the ability to have your legal documents revised as necessary, and when appropriate, have access to our elder care coordinator. That's a person who assists with whatever help our clients may need as they age. That could be setting tours of various facilities, advocating for our clients, etc. So if you heard something in today's broadcast which resonates with you, an area in which you may be able to help, which we may be able to help, please call Nugen Law at 260-925-3738. Thank you, Jesslyn, for joining me, and to our listeners today. You have provided invaluable insight into key elements of elder law and asset protection. I look forward to speaking with everybody next weekend, Saturday at 9 a.m. Enjoy your weekend.
You've been listening to Preserving Your Dignity and Your Money, Planning for Successful Aging with Nugen Law. For more information, log on to NugenLaw.com or email help@NugenLaw.com. Nothing stated in today's program should be considered as legal advice, should not be considered as having created an attorney-client relationship between show host and guests and any listener. Nugen Law is not liable for anything that happens as a result of a listener relying on provided information as legal advice. The content is for informational purposes only.
Podcasts by Federated Media.